The Free State Asbestos Project arrest has been, as we've been reporting in the headlines for the past 2 days, and some media houses opted to name the suspects before appearing and pleading in court, while others did not. And the country's Criminal Procedure Act of 1977 prohibits the publication of the identity of the accused before they appear in court and plead, and this is to prevent undue prejudice to a person before the prosecuting authority decides to prosecute. But some media houses appear to have a different understanding on this. I want to bring in back the Elton Hart, an attorney at the University of Johannesburg's Law Clinic. Councillor, you back with us? Can you hear us loud and clear?
Yes, Blaine, I can hear you loud and clear.
All right. I just want to read something. You were talking about the South African Police Act, right? I want to read something from the Criminal Procedure Act, which you've mentioned. So there's no misunderstanding. And forgive me, it's a bit small text here. But in terms of the Criminal Procedure Act of 1977, 153B, no person shall at any stage before the appearance of an accused in a court upon any charge referred to in section 1533 or at any stage after such appearance before the accused has pleaded to the charge, publish in any manner whatever any information relating to the charge in question. What is unclear about this?
Blaine, if one looks at the Police Act, and that is applicable to our law enforcement agencies, they are not allowed to name suspects prior to their arrest and their court appearance. However, if one looks at the Criminal Procedure Act, then there's nothing in the Criminal Procedure Act that prohibits the authorities or whoever from doing that. So from the police side, they should not make the suspects aware as to they are suspects in an ongoing investigation. But further up the line, and even the broader public, there's nothing that stops the broader public from actually making known the names of individuals if the names is known to them, and that includes the media houses. And this is where there is certain loopholes pertaining to our criminal justice system, because the problem is that naming a suspect prior to his arrest might afford him the opportunity to actually flee the country for those suspects who has the means. And a classical example was when Grace Mugabe was an alleged suspect in an assault case. She got onto a plane and she left the country and she never returned. So that is the problem why they want people not to disclose the names. But if one looks at what was transpiring at the Zondo Commission, people testified at the Zondo Commission, so names were called there. The names of the companies involved in the asbestos project was named there. So it was now easy for people to put one and one together and say, who's the directors of that company? Oh, there are 4 directors, so these 4 are the other 4. So it became an open secret. So that's where the technical problems lie. And in terms of the Criminal Procedure Act, they say if a witness' life is in danger. So now one has to look at this case. One of these 7 suspects now, was their lives in danger? I don't think so. Is it a sexual offense case or something related to sexual offenses? No. Is it one of these accused persons minors? No. Which means there was nothing that actually stopped the media houses. There's nothing in law that you can actually even institute a civil action to sue them to say that they've caused you damage. Because if they say you're going to be arrested and you're violently arrested, then it's the truth. So that's where the problem lies.
Something that is very clear is that the identity of the complainant in a sexual matter must always be confidential, correct?
Not always confidential. In a sexual matter, it depends on who's involved. If there's minors involved, then the identities of the minors and sometimes the accused person will also be hidden so that because if they know who's the accused, then they might track it down to the minor. So in those instances, they will say, keep both of the public record. But the moment it's like when it's sexual offenses and it's 2 major people, then there's nothing stopping the media houses or whoever to publish the names after their first appearance. Now, here it's after their first appearance. So they need to give them time to appear first. But now here we have the Zondo Commission running on the one side, and people has already named people there. So now in our law also we have the principles of privilege, confidentiality, and privacy.
Right.
So the moment a third party discloses information, confidentiality is lost. So there's no more confidentiality, and then other third parties is exempted, and they can use that information. And this is exactly what happened here. Because the moment the Hawk spokesperson, when he spoke to one of your colleagues on the other channels, he said it was the directors of a specific company that will be arrested. So for those people to do a CIPC check becomes relatively easy, and they can get the information and then put these people's name out in the public domain. And once it's in the public domain, it's done.
Let's just break it down and just simplify this for the viewer watching and give a practical example, as you were just talking about it now. The suspects that are appearing in the Bloemfontein Magistrates Court, if we know as the media the names of the people, which we do, is it fine that we release the names to the public? And what is the rationale behind it? Just give us a practical example in a nutshell, if you can sum it up.
Because now they've already been arrested, so I cannot see that there is something to the detriment of the administration of justice, that these guys might flee or they might destroy evidence, because they've already been arrested. So if the media now publishes their names, I cannot see that there should be a problem, because this has also been an open secret. As I said earlier, it's been in the public domain already. So most probably people know already who was connected. And so I don't see any action that these oaks can take. I don't even see a constitutional right being violated of these guys, because the media also has a right to publish and without fear of favor. So there is two constitutionally protected rights by the media and these people. So in essence, the media is protected if one look at this.
So talk to us about social media. You often see, sometimes even in sexual offences cases, that the people are being named, their pictures are out there before they appear in court. What sort of, if people, the individual, the media, I guess, is held at a higher standard in terms of ethical reporting. But what about the general public? How do you police that? Realistically, can you even prosecute? I mean, where do you start in terms of, prosecuting thousands of people?
I mean, social media and or electronic platforms has been with us now for the better 10 years, if I'm not mistaken. And the problem is that we currently have a cybercrimes bill that's not yet an act. So in that, they're trying to regulate and deal with these things. And our ECTA, which is the Electronic Communication and Transaction Act, is very limited on. And the cybercrimes bill was now also somehow a tool that the investigators can use to actually look at who's actually publishing these things. And that you can join now with the Criminal Procedure Act in section 153 and 154, which actually sets out when certain information should not be made available. And obviously, if you transgress a national legislation or any legislation for that matter in South Africa, it's a criminal offense, and you can be charged with it. It's just now our authorities, I think, maybe they lack the manpower to actually execute what this legislation empowers them to do. But as it stands now, the cybercrimes bill is somehow, it's still a bill, it's not an act yet and still not yet operational. So we have problems, and I think there is where our legislature should step in and actually set out clear guidelines as to when a person should do 1, 2, 3, under what circumstances, and when you are prohibited. But the CPA is clear. Under certain instances, when you deal with certain individuals, you cannot make that information public prior to their first court appearance, and even when the court issue a directive after that first appearance, that information should not be made known at all, because there's minors, it's sexual offenses, those type of things. There's already something in the legislation. So it's now our law enforcement agencies that need to check and see who was the publisher of this information, and then our media houses should now make sure that they don't fall in that trap or step in that trap that they make known. But I think in this instance of the asbestos project, I cannot fault the media houses at this present moment, because things were already in the public when they started reporting, because the media houses was at the Zondo Commission. They were all over the show, busy reporting and giving the public information as to what happened with the taxpayers' money, which is also their duty that as media houses that they have to make sure that the public knows what's happening to their money. And unfortunately for these blokes, the media houses got the information there, and it was out. It's an open secret.
Alton, just to button up this interview, if the media is found wanting, if they are found that they contravened the South African Police Act as well as the Criminal Procedure Act, what penalties are they facing?
Obviously, the person will first go to the Broadcasting Complaints Commission to go and lay a complaint against the media house. And Once they look at the conduct of the media houses, was it free, was it fair, was it in line with things, then only can they now say the media house was wrong. And once that is, then one can now look at the National Prosecuting Authority to lay a complaint against the media houses and actually prosecute them. But that is just a long way down the line. But if the media houses stick to what's currently in the legislation, they cannot be faulted. And once somebody else publishes something on a social media platform and a media house gets a hold of it, it's out in the public domain. Then they can use it because confidentiality is lost.
Elton Hart, an attorney at the University of Johannesburg's Law Clinic. Sir, we thank you very much indeed for your perspective. Be well.
Thank you, Blaine.